There seems to be an awful lot of sad stories in the news today, and there are thousands missing. Does anybody care? We built a channel where we talk about those faces. Talking news. Cassie Barons has still not been found, and it's been 2 years since her case first hit the spotlight. Breaking. Child Gable and Lori Vallow both behind bars. Sarah Galloway was found. She wasn't found alive. What happened to Sarah Galloway?
It's too heartbreaking to share.
Children are still missing. Children like Dorsey. Nor is she. He just got away with it. Welcome to Talking News. Hello everyone. My name is Debbie. We use big stories to push little faces.
Hello guys, welcome to Talking News. Chasing a murder. Right now we're continuing the coverage of the hearing for the prosecutor Rob Wood on the Lori Vallow and Chad Daybell case. Now I want to let you guys know that a lot of this is going to be a lot of my opinion based on this. So we're going to be talking about what we're seeing, as well as addressing a few things that, you know, we see happening within the personal part of this. So we all know that Chad Daybell's attorney, John Pryor, and Lori Daybell's attorney, Mark Means, has accused Rob Wood of misconduct and various other things. Yesterday, they brought in a paid witness, maybe two. Wasn't sure if the other guy, which I'm not worried about anyways, was paid or not, but regardless, their testimony really was irrelevant. They really don't know what's going on with the case. They don't understand the people involved, and they especially didn't even understand the people that they were representing. So Mark Means is not normally a criminal law attorney. He took on this case. None of us can figure out why he took this case, so I'm kind of interested to know why. And Rob Wood was recorded saying a few things that kind of sounded, if you listen to it, depends on how you listen to it, that seems a little demeaning to Mark Means. But I think what he was trying to say was that he was concerned about Lori having the proper attorney to represent her so that she gets, you know, represented in the way that any person that's being accused of a crime like this should be represented. Now today they had closing arguments of the hearing yesterday, and Pryor was surprisingly short. I don't want to go into that, but I want to say I can't blame him. This was strange because, you know, he pretty much ran the show yesterday, and whenever Mark Means would take over the show, you could tell that he was struggling a bit and mostly argued. Pryor was definitely the man that was pulling and moving the, you know, everything the way that it should be moved when you're prosecuting, especially for something like this. He was addressing facts, at least trying to push and even manipulate facts in, which is what he's good at. I'm going to be honest, John Pryor is a pretty good attorney, but he has a bit of a background, and we won't go over that right now. So during this, during the closing, John Pryor starts off, he's very short, he's to the point. Then Mark Means takes the reins. He starts off kind of calm, relatively calm, and starts addressing several issues and accusations that Rob Wood was coaxing witnesses and that he might be a witness. He was not happy with the fact that Rob Wood flew to Hawaii to speak with some of these witnesses and wanted to know why he did that. And a question mark went up in my mind because I've been learning a lot since I've started this channel, especially in law, because I knew nothing at all. But many times I have seen where attorneys do, meet and greet. They even go out to the scene, immediately when the police are called out to the scene. So I was confused as to why that was a big deal for Mark Means. But as he started giving his viewpoint of why Rob Wood should no longer be the prosecutor on this case, he started to get a little bit more fidgety. And then he started leaning aggressively into the camera. And then he began to get louder and louder. And you could see that he was struggling with something personal there. He had a lot of anger built up in him, and it actually, quite frankly, raised a lot of flags for me and concerns for Rob Wood. So, let's say that Rob Wood did mean whatever he said about Mark Means in a way, in a disrespectful way, okay? Let's just say he did that. Well, he did this in private, and nobody would have even known about it if we didn't have this hearing. A lot of people believe that Mark Means is doing this mainly because he was butthurt. That's their opinion, in my opinion. And now, what he's done is actually just drawn a lot more attention to it. And it actually showed that very aggressive, which seems he might have some anger issues, to what could be thousands and thousands of people. So let me show you a clip.
Judge, she immediately turned on the camera and looked directly in Mr. Means' eyes. And I said right after that, why were you looking at Mr. Means?
Your Honor, I'm going to object for hearsay.
This is argument, Judge. This is argument. This isn't the presentation of evidence.
I understand, but you're still referencing a specific comment someone made out of in a separate proceeding. I think that's hearsay.
Okay. Well, Judge, my concern is this, is that having to bring up the subject of whether Miss Gibbs was looking at Mr. Wood when I said that, and the fact that I brought it up, and the fact is, Judge, I observed Miss Gibbs look in the eyes of Mr. Wood when I'm questioning about what sort of conversations they had. That causes me great concern. And everybody in the world can look at it on YouTube and see that there was concern. So what assurance is the court going to be able to give me that these meet and greets that Mr. Wood has engaged in, these 20-minute monologues, have not occurred with every other witness in this case?
Okay, so there's one of the concerns that I had with the defense, because it seems to me a lot of, and they're lawyers, of course, they're going to be able to work around that law to send some scary little messages. And I believe that right there, what John Pryor said at the end right there, what makes you think that he didn't have these 20-minute monologue with other witnesses? And I want you to keep that.
Because if the court cannot give me assurance, you're going to require me to go to every witness with an investigator, interview them, and question them in detail about what Mr. Wood has talked to them about, and whether this meet and greet tactic that is completely unprofessional, that is completely unethical, that is completely wrong, was conducted on other witnesses in this case.
So I found this very interesting that John Pryor was the one that addressed ethical issues. And this is why. So a woman comes into John Pryor's office and claims that he was forcing himself on her at his office. He was also indicted. He was facing a maximum of 6 months in jail and a $1,000 fine when he was sentenced in November of that year. So Pryor was indicted by a grand jury for a felony battery with the intent to commit rape after being accused of attacking a 20-year-old woman who says she came to his Napa office seeking a job and advice on a child custody case. Now, let's say he's not guilty. Pryor said that he paid to have sexual intercourse with her. How ethical is that, ladies and gentlemen? So this doesn't make sense that he thought he had the right to judge somebody on ethical standards when a client of his, he was paying her for sexual intercourse. I think that tops anything they have or throwing on Rob Wood. This defense team seemed to be full of speculation and putting the words in the mouths of everybody involved. So now they're putting words into Rob Wood's mouth, saying that him speaking to Summer, Lori Vallows' sister, is a way to get a message to her that there's going to be murder charges and she might want to start talking. Okay, so there's something else I want to address real quick. So we heard Pryor speaking about a witness, and he asked her a question. Basically, did Rob Wood tell you or coach you on what to say today? And so basically, Pryor's accusing Wood of coaching Melanie Gibb before she took the witness stand. So here you go. Lawyers do prepare their witnesses, which could be seen as coaching for a trial. And for those that don't know the difference, because they're not lawyers, coaching could be interpreted to them as the preparing. So attorneys always prepare their witnesses or client to answer questions for trial. And this is essential. And this is because you want your witness to project confidence. Of course, there was no jury there, but also, to show trustworthiness to the jury. And as Pryor knows, you definitely don't want your witnesses helping the other side. So most of us know this, that attorneys are expected to instruct their witnesses on how to behave during questioning, as well as how to properly and confidently give answers. But there's a fine line between coaching and preparing, guys. And Pryor's trying to push this on coaching instead of preparing. That was a very awkward moment when Pryor asked if, I can't remember word for word, if Rob Wood had coached her. And she did look straight at Rob Wood, not knowing how to answer that question because she didn't understand what was happening. So I really think Mr. Pryor likes to make people feel really uncomfortable, especially those that he knows that he can make feel uncomfortable. Okay, let's move on to Mark Means. Now, Mark Means, watch him. He starts to get more and more and more excited as he testifies why they're there in the first place.
Shiflett, and again, summary, he engages in derogatory remarks as if we are in third grade in an attempt to, according to Dr. Davison, affect this witness. He summarizes by saying that there are minimal attempts from the state here to actually get the witness statement rather than to say his own. That there are derogatory remarks regarding defendant Chad Daybell and myself. And when you actually look at the recording, he's also in certain ways derogatory toward Mr. Pryor and my client when you look at his opinions that are being expressed. He also attempts to bring in LDS doctrine as an authoritative speaker on behalf of that doctrine. He also attempts to assimilate or build a commonality with Mrs. Shiflett based on mutual beliefs in the LDS Church, which obviously is completely inappropriate. He also goes on to say that Mr. Wood engaged in coaching, testifying, and had an effort to unduly influence the witness. He attempted to shut down the witness. He attempted to control the narrative. And there's little interest in what the witness's information that will be provided. He's attempting to increase his credibility through derogatory comments and mutual association with religious beliefs. He attempts to, there's a prima facie influence of the witness. He halted any disagreement by...
So you can see Mark Means is extremely emotional here. He gets so fidgety. So that's why I say I think a lot of this is personal, but also a way to manipulate the system and aggravate the prosecutor, making it difficult for him to do his job. Again, guys, this is my opinion on this video. Nothing more. I'm not an attorney. So on this case, I have become a little bit personally involved with this case, and that's because of how everything's gone down. The lack of the initial investigation when the accusations first started flying, and Charles went out of his way to try to bring attention to the danger for the children. You must remember and never let that ever slip your mind of how these children were found on this piece of property. Now, we keep hearing that there's going to be conspiracy to murder charges, and all of this distraction from the defense is really making it difficult for Rob Wood. And that's probably, like I mentioned earlier, part of that plan. Now, I do want to mention again, I don't know how the heck Mark Means is getting away with posting what he posted on Twitter. I don't understand why Rob Wood hasn't addressed that. But the witnesses involved with this case don't need to be afraid of anything, because Lori isn't going to be getting out from behind bars. All right, so let's continue on with the final day, where these two defense attorneys, to be nice, try to take Rob Wood off this case. So on this part of the video, this is where we're going to listen to Mark Means. He's extremely excited at this point, talking about what Rob Wood did, and accuses Rob Wood of coaxing, making the witness feel uncomfortable, which we all know is not true, and on and on. So here you go. Listen for yourself.
No. He then had, by Dr. Newton, put Shiflett in a compromised position. And just thinking of how this is going to affect ultimately this case is mind-boggling at this point in time. He says his behavior bordered on intimidation, that he attempted to possibly circumvent the attorney-client privilege between myself and my client. He goes on to say that the use of religious beliefs, affiliation, and authority is an improper use. The derogatory remarks are improper, and that these remarks and his monologue serve the purpose of predisposing a witness against the defense. This not only he said this violated the spirit, if not the letter of the law of the Idaho Rules of Professional Conduct, and potentially the Idaho laws regarding witness tampering. He also goes on to say that there are coercive aspects.
So we'll go ahead and end it there. We know that they had paid witnesses come in, making huge, I could not believe the speculation and the words that they put into people's mouths, then claim other people are unethical. So Dr. James Davidson is supposed to be a superior psychological evaluator. Seemed like his evaluations was based on wherever the money come from. And I am not a big fan of paid witnesses. I think that is corruption at its best. So Davidson actually only did an evaluation of the transcript in which they thought would take Rob Wood down. But again, he didn't even get the full transcript. He had the full audio, but not the full transcript. And still, the fact that he didn't know, that he didn't have the full transcript, says that he didn't research well. So after several days of waiting to see, to get to the closing arguments of this, which happened Friday around 1:30 Idaho time, and that was on January 8th of 2021. The defendant attorneys continued to attack Rob Wood and accuse him of unethical conduct, as well as coaxing, witnesses and so on and so on. But a lot of us knew once they couldn't get their paid witnesses to say that they've seen an attorney basically be taken off a case for stuff like this, and that he should be taken off the case for something like this. We kind of knew which way it was going to go. So Judge Bryce allowed them to make their closing arguments, and he had a little bit of trouble with Means going off in directions that he probably shouldn't have, having to remind Mr. Means, trying his best not to, that this is not appropriate for now. This is not where that goes. And then also they had to address a rebuttal. So they had new information come in, which could have hurt or not hurt Rob Wood. I'm going to leave it to an attorney to talk about the details on that one, because I can't. So getting to the end of the story, Bryce basically, after hearing, the closing arguments plus the rebuttal argument, took about an hour and 10-minute break to research and go over a few of the laws and, past cases. When he finally returned, he went over the list a mile long that defense put up against Rob Wood and accusing him of, stating that he didn't find anything unlawful, he didn't find misconduct or anything else. And, his final word was Rob Wood would remain on the case. Now, there are a lot of people excited that Rob Wood gets to remain on the case, and for right reasons, I'm glad he got to remain on the case. Now, I am confused by Rob Wood myself. Is he, I don't know how he's playing his cards or how he works. I don't know him. There's times that he gives me, I have red flags fly up for him. I can't talk today. And then there's times that I think, well, maybe this is just the game that he's playing. So, unfortunately, the justice is in the hands of people we just don't know. And we have to hope that they do their job the way that they're supposed to and bring justice for all these so many people that have been hurt and lives taken unnecessarily by a crazy couple and group of people. I had to put this together very quickly, and there was a lot more I wanted to say, but unfortunately I do all this alone, so I can't do but so much in a day. You have to research it, put it together, blah, 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 blah. But the main concern, guys, is getting justice for all these poor folks. And hopefully these witnesses, like Melanie Gibb, do not get intimidated by this. Your strength is your best part of everybody, really. Your strength that you carry and your ability to do what's right when everybody else is doing wrong shows just who you are. And I'm one of those people that don't follow the sheep. I just don't. I do my own thing. Sometimes it makes things difficult. but I get a satisfaction knowing that I can't be bullied and that I can stand for what's right and what I believe in. So hopefully these witnesses are able to do the same. Don't forget to check out these faces. We still have girls missing. And at the end of this, I'm going to run a small piece during the closing arguments. Thank you guys for watching. Love you very much. I appreciate each and every one of you. And I'll see you guys soon.
In determining then these allegations in the standard I've announced, then I've considered the evidence submitted, including the submitted pleadings and exhibit and the testimony of the three witnesses, including Garrett Smith, the attorney from Arizona, the expert witness opinions and testimony and reports of Dr. James Davidson and Dr. Samuel Newton. I've also considered, of course, the transcript of the audio recording, as well as listened to the recording of the potential witness in this case and her discussion she had with Mr. Wood, which was submitted in the evidence of this. The case of Cosman versus Dinius, which is 165 Idaho 375, which states unequivocally that the district court appropriately recognized that whether to issue sanctions for an ethical violation is a decision for the Idaho State Bar. So in other words, there's a separate governing agency that would make a determination as to whether or not any sanction should be imposed for violation of the Idaho Rules of Professional Conduct. Now, I understand that as the sitting and presiding court in this case, if I were convinced that an acting prosecutor was engaged in conduct that would result in a fair trial, then I would have an inherent ability to grant this motion, even though, as I have mentioned, I don't see any prior precedent, or I haven't ever heard of that happening. The Idaho Constitution under Article 5, Section 2 does grant the court with the inherent right to administer justice in a case. But again, the standard I'm looking at for the motion would be the standard out of the State versus Paperno, New York case, which is that the question of one, did the pretrial activity of Mr. Wood in this case render his participation in the trial unfair? And two, was there a significant possibility that this pretrial activity will be a material issue in the case? In this case, then, we're dealing with the comments that were made to a potential material witness, who is the sister of the defendant, Lori Vallow. And as Mr. Evans pointed out during cross-examination, this witness may or may not ever be called to testify at a trial. So that's something I have to consider. Action. So without knowing whether or not this potential witness will ever be called to testify at a trial, the court cannot find at this time that the interaction between Mr. Wood and the witness would render Mr. Wood's continued participation in this case unfair, and cannot determine that the prosecutor's pretrial activity will be a material issue in this case. For those reasons, then, the motions to disqualify Mr. Wood are denied.